promoter is a person who comes up with an idea of forming a company. We have duties of a promoter. The duties are classified into two. We have fiduciary duties and general duties. Under fiduciary duties are also called common law duties. And the following are duties under fiduciary or common law. The promoter is required to act honestly, in good faith, and for the best interest of the company. That is point 1. Point 2. There is duty of disclosure of any interest that the promoter may have in a transaction involving a company. Point 3. Duty to account for any money or property that comes into his control in which relates to the company. Point 4. Duty not to make secret profit. Then we go to general duties. Point 1. To choose the name of the company. Point number 2. To pay all the preliminary expenses incurred. Point 3. To cause the company to be registered. Point 4. To prepare all the official documents that are needed to register a company. Point 5. To acquire the services of the directors on behalf of the company. Point 6. To acquire capital and property on behalf of the company. Point 7. To enter into transactions and contracts on behalf of the company, which are into brackets pre-incorporation acts. Then we move to the remuneration of promoters. Since the promoter is not an agent or an employee of the company, he or she is not entitled to any remuneration. However, the company's internal constitution can make a provision for the promoter to be rewarded for the service he has provided to the company. Some of the rewards are as follows. He can be allowed to sell his business undertaking to the company at a profit which must be disclosed. He can be allowed to sell assets and property to the company in return of free fully paid shares. The promoter may be allowed to facilitate transactions between a company and a third party for a commission which must be disclosed. The promoter can be made one of the first directors of the company. In future, the company may decide to give a promoter some management shares for free. The promoter may be allowed to acquire shares in the company at a price that is lower than the market value of those shares. Then we move to the incorporation contracts. This refers to a contract that is entered into on behalf of the company before it is registered, usually by the promoters. The general rule is that such a contract cannot be enforced against the company. The court has laid also down a number of rules in relation to such contracts, which are commonly called the rules of incorporation contract. And that question was tested in November 2020, question 1A. And the following are the rules. Before a company is incorporated, it has no legal existence and therefore cannot contract or have agents. And this was explained in the case of Kellner and versus Baxter, 1866. In this case, the promoters of the company, to brackets a hotel, entered into a contract for hotel to be supplied with goods before it was registered. Upon its registration, the company rectified the contract and goods were supplied and used by the hotel. However, before the money was paid, the company went into liquidation. The promoters were sued by the suppliers on the contract, but they argued that the responsibilities had been transferred to the company due to the rectification of the contract. The court held that the promoters were liable since at the time of making the contract, the company did not exist legally and could not contract. Point number 2. At a common law, a person who purports to contract as an agent but the principle does not exist at the time will be held personally liable for the contract. Point 3. At common law, a person who purports to contract with an non-existent person such a contract is void. Point 4. At common law, a company cannot after incorporation ratify a pre-incorporation contract.